Good evening and a warm welcome to you all to the third edition of the Art of Arbitration taken by our good friend Mr. Ashokapathy. Today's session is going to be an interactive session. He is going to largely deal with the intervention of court with regard to arbitration proceedings covered under section 5, 8, 9, 12, 19, 15, 16, and 27. Most likely, I think he may be skipping section 34, 37, and part 2 of the Arbitration Act. It is going to be an interactive session. And to start with, I will commence a few questions. Before that, I will ask the speaker to address us. Thank you.
Good evening, friends. Today we will discuss about certain provisions of the Act, wherein the Act provides for the intervention of the court in certain circumstances. So this will give a light of how much intervention the court is entitled to, and in what are the places where the arbitration is dependent on the court for its intervention to conduct its proceedings in a smooth manner. So I can straight away go ahead with the questions, and so that we will save some more time for the questions.
To start with, I will spin off few questions. Ashok, can a suit for permanent injunction, which is under the Specific Relief Act, be also referred to arbitration?
A suit for specific injunction, if you broadly see this will look as if it is a gest and rem which is being dealt with. And as we saw in the previous session, a gest and rem cannot be arbitrated. However, there was a difference made where a gest and rem is within a particular ambit of the contract, and the relief sought for also is within the parties specific, and it is not at large. Then these disputes can be resolved. In fact, most of the cases which have come under Section 8, which has gone up to the Supreme Court, for instance, the Sundaram Finance case, has also been under the provisions of Specific Relief Act. The suit was for specific injunction, restraining the financial institution from interfering with the, rather the respondent had filed a suit restraining the financial institution from interfering with this peaceful activities. And such a suit, the Sundaram Finance had filed a Section 8 application, and which was upheld. The application was upheld. The same has been also upheld in Anand Gajapati Raju's case also. So it can be filed.
So can we have citations of that one?
Yes, I can give you the citation. 1 second. With respect to Sundaram Finance Limited versus N. Tanakkam, it is Manu, Supreme Court 0177 of 2015. And Raju Gajapati Raju is Manu SC 0281 2000.
Okay. I will be typing these citations after sometimes in the chat box. My second question would be, can the defendant who does not have the agreement copy with them, but has knowledge that an agreement which is in possession of the plaintiff has the arbitration clause, how will he get the dispute referred to the arbitration?
Yes, the recent amendment in to the Act in the year 2015 paves way for this, and rather it clarifies this issue. What has happened is prior to that, there was no specific provision for the same. It only stated that a party should produce the original or the certified copy. Now what has happened is the amendment has come into such an extent which says along with the application under Section 8, another application also will be filed by the party calling for the document from the plaintiff to produce the same as he has the original or the certified copy. So along with that application, now it can be filed.
Thank you. What is the difference between Section 26 and Section 27 of the Act? Can the arbitrator call for the witness under Section 26 of the Act?
See, 26 deals with the arbitrator's power to appoint experts, and 27 deals with the party seeking the tribunal's permission to apply to the court to bring in the expert witness and also the other witnesses. So what happens, and calling for documents also, what happens is there's a subtle difference. When the arbitrator requires only the expert to be invited or an advice is required, then he can approach directly to the expert, and the expert opinion can be obtained. And thereafter, the expert will be placed before the report will be placed before both the parties, and they will also be given an option of cross-examining the expert on the said report. However, in all cases, it is not possible that the arbitrator will be able to engage an expert, or will the party be agreeable for the same. So in such cases, what happens is the parties seek the permission of the arbitrator and thereafter file an application before the Honorable Court for summoning the expert, or for that matter, a witness or some officials to call for a document. So it's like they are per se, they go on the same footing. But however, 26 is only with respect to the experts to be appointed by the arbitrator. 27 is on a larger perspective. In cases where the arbitrator has the control and he is able to, and the parties cooperate, it is always easier to complete the evidence and the opinion through 26 itself, because it's less time consuming. Whereas under 27, it takes a lot of time filing an application, getting it done. In fact, one of my cases has gone to under section 27 to the court, and it is pending for the past 3 years, where the parties have been taking time, and they are reporting me before the arbitration tribunal that they are still in the process of getting the orders under 27. So that time consumption is one big drawback under 27. So wherever it is possible, they can go under 26.
What are the normal procedures adapted while recording evidences? Or just like that, what we try to do in citizen court by way of filing proof of debit, marking of document, subjecting the witnesses themselves to cross-examination, etc., or it would be in a very informal way.
As far as an arbitration proceedings, we conduct it in as far as possible in a very informal manner. However, the requisite aspects of recording evidence has to be followed, namely the taking of oath and bringing the parties with confidential, and that they are not tutored, of course, affront of the proceedings. So all these things are taken care. What your question was of two parts, if I remember, if I can recollect. One was, how do you conduct the evidence, and what is the procedure that you follow? With respect to the procedures that are followed, basically the provisions of the Act says that it is left to the parties to decide at the inception or even before on what type of process they want to have their evidence recorded. So it's party autonomy which is predominant here, as I had already told you all in the previous sessions. So when you go by the party's autonomy, what happens is the party can also draw the procedure how they want to conduct the evidence. But if the process is not derived, then it is done in the preliminary hearing, or even if it is not done in the time of preliminary hearing, the arbitrator is entitled to draw a procedure at a later point of time before the conduct of the evidence. Here also what happens is the most predominant portion is the admissibility of evidence, documentary evidences. When it comes to, it is usually by way of exchange of an affidavit with regarding to the admission and denial of documents. This curtails the time of the tribunal to a great extent. So it identifies what are the documents which are objected to. Of course, in one arbitration where I appeared as a counsel, the other side had objected to every other document, and the tribunal asked, you are objecting even to your own document, because I had marked one of their documents as my evidence. Then they realized that it was a fault, and then the arbitrator said, you have to go through each and everything and let's make some sense on this admission and denial of documents. Thereafter, it was exchanged. when it was exchanged, hardly about 3 documents out of the 28 and odd documents that were filed by me was objected. So the dispute also narrowed down, and this is predominantly accepted in arbitration process. Apart from that, yes, chief examination is now by way of a proof affidavit, and the regular cross-examination go through it.
And this leads to the another question: is there any any type of citations or a list of do's and don'ts that has been given by the courts in while taking recording evidences? Is there
See,
any
as I told you, that this is predominantly parties' autonomy here, and the procedure of the arbitration tribunal, apart from the party, the arbitrator are supposed to be the masters of their proceedings. So if the parties have not agreed upon, then it comes to the arbitrator. What the courts can say is, if some procedure which is followed by the arbitrator is not in accordance with the natural process of natural justice, following the natural justice, only there it comes to the picture that they can interfere. Otherwise, I don't think so there is any patent or strict instructions given by the court. To my knowledge, I have not seen.
How does one execute the interim order passed by the arbitrator under Section 17?
Section 17, actually what happens is the Section 17 provides the arbitrator the power to issue interim orders. Now, when it comes to the provisions of enforcing it, there are a lot of difficulties. This was brought out in the 246 Law Commission, and various judgments also were having this as a repeated question, how to enforce the Section 17. There were in fact many who were filing Section 9 application before the court on the ground that they were not able to execute a Section 17 order. So these were going on. It was only pursuant to this, there was an amendment to the section which said an order passed by the arbitral tribunal will be treated in par with order with the as an order passed by the court itself. So this gave a lot of truth to the proceedings. However, the practicality is it has been very difficult to enforce Section 17 order. Recently, the judgment of His Lordship Justice G.R. Swaminathan had touched upon this and had come to the conclusion that the orders of the arbitral tribunal shall follow the procedure as laid down under Section 36 of CPC, wherein an order of the court which is to be followed in another district, how it would be followed, the same manner has to be followed. He has also put in a rider there saying that because of a lot of fraudulent activities that are occurring, the process has to be made only by the advocate who is practicing in that particular court. So I don't know how we are going to regulate an advocate practicing in that particular court, because I don't think so we have any system where we are supposed to practice in only one bar and not in the other. But however, the judgment says that 36 will be followed, and the orders will be sent to the district court. From there, the process will be taken, and it will be served on the person to whom it is directed to be enforced. So this is how at present Section 17 is being mentioned. However, we also find that there are many orders which are passed by the tribunal are sent to the registrar's office for attachment of immovable property, or bank for attachment of their bank account. All these things are being carried out and being attached also. So this today, as on date, the limited procedure that is available is only under CPC, which is 36, as per the judgment of the court. I'll share the citation for that. It is Manu TN 5438 of 2018. Did I tell this case name? I think I didn't tell the case name. It is Sundaram Finance Limited versus Sakti Vale and others.
Okay. Now the next question is, it's a bit ticklish one. How to identify a bias of an arbitrator? Or how to prove a bias of an arbitrator before court?
How to prove, is it?
Yes.
See, bias of an arbitrator is only based on his action. There is one famous book, How to Be an Arbitrator. I forgot the author of the name of the author. I'm not able to get it immediately. In that book, he says, if an arbitrator looks at one particular party and talks continuously, it can be treated as bias. So the yardstick is something which cannot be articulated by words. It is only the conduct of the arbitrator which a person suspects his act. So bias at the initial stage is only based on a suspicion, and which can happen based on the body language or the way in which the parties are treated, or the way in which a particular preference is given to a particular party. All these things can be act of bias. Apart from that, what has happened now is after the amendment, a big list is given on Schedule 5. Dehors the ones which are mentioned in Schedule 7, whatever rest is, they all say that these acts, if the arbitrator comes within these provisions of these enumerated in Schedule 5, it can be construed that he has a chances of bias. It is a guidelines which has been given. Again, it has to be noted that just because an arbitrator comes within that purview of Schedule 5, it doesn't mean straight jacket that he becomes biased. It is not so. It is only a guidelines which is given, and it is not total ineligibility. The total ineligibility is the clauses which are provided under Schedule 7, which are also in Schedule 5. So whatever we are talking about is Dehors Schedule 7, items mentioned in Schedule 7. The rest of it are only a guidelines given to the parties, which says these things, there is a slight presumption against the arbitrator with respect to bias. So that's how bias can be identified.
How does normally court deal with the allegation of bias against an arbitrator?
As on date, unfortunately, that's totally my opinion. Unfortunately, the courts are now going by the semblance of the bias or the guidelines that is given, and coming to a predominant conclusion that the arbitrator is biased. I would always suggest that a bias doesn't have its own legs. I repeatedly keep telling this. Bias does not have its own legs to stand. It needs an act which controls and which confirms that act of bias. Say, for instance, let me assume that a particular arbitrator in a proceedings is biased. So I file an application before him under section 12 or 13, and I tell him 12, and I tell him that you are biased and for these act. And he gives an order stating that he is not. And that order I can challenge only under 34 and not prior to that. I have to wait till he passes the order. I was thinking why this provision has been given in the act. Why not I straight away go ahead and challenge the arbitration proceedings, because that person is biased, and how am I supposed to conduct a proceedings again with a person who I feel that he is biased? These are the questions that went through my mind. But then the act has been placing these provisions for a particular purpose. What happens here is, in case of a bias, the bias is, as I said, has to have a leg for it to stand. And if the bias allegation that I have made, even after that, the arbitrator goes on and passes an award in my favor, now where do I find the bias now? I won't be able to find the bias. So if I still see that bias, and when the award is against me, it is against me in such a way that it concurs with my contention that he was biased, then it has its own legs. That's where section 34 comes in, and the award can be challenged. So to challenge a bias, it has to have its leg. So only after an award is passed, it can be coming into full-fledged whether there is real bias or not. Till then, it is only a suspicion and not a conclusive aspect.
So the question of bias could be taken as a ground only under section 34,
Yes,
not before that.
but you have to raise it whenever you have the suspicion. It is always better that it is not always better, it is to be raised immediately. And whatever the arbitrator decides after that, we go by that. And when we find that it has a base, whatever allegations that we were stating were not allegations, were actually factual, then we can challenge it under 34.
I'm just repeating the question once again. How to infer or how to prove a suspected bias during the proceedings? That is by making an application and for
Okay, you are
getting
asking
it.
about the procedure.
Yes.
See, what happens is the moment you have you find that the acts of an arbitrator is biased or is impartial or it's not independent, then you have to file an application under section 12(3). And the procedure is mentioned in section 13 of the Act, where you will file an application before the arbitrator. And since he is entitled to decide on the said application by himself, he will decide on that. That's how it has to be immediately raised up. Similarly, whenever a question with respect to jurisdiction comes in, that also has to be raised immediately before the arbitrator under section 16. So he has the right to decide on his own jurisdiction also. Competence comes into play, and thereafter he can decide that also. And whatever decisions that are made by the arbitrator in these circumstances can be challenged under 34. And in case under section 16, when a jurisdiction is questioned and the arbitrator goes in favor of the person who is objecting to it, the aggrieved party can straight away go on appeal to the court.
Under what circumstances or during which portion of the arbitration proceedings can a court intervene? Except final, I'm asking prior to award.
Prior to award. See, there are many sections which are which talk about the intervention of the court. Say, for instance, I would even say section 5 and 8 is an intervention of the court, but it is section 8 is an intervention of the court, but the intervention here is to refer the parties to arbitration. So that comes under section 8 also, it is available. Then whenever it comes to appointment of an arbitrator, that is also an intervention by the court to appoint an arbitrator. Now, once the arbitration proceedings has commenced, and after that, can there be an intervention by the court? Yes, especially when there is a change in mandate. Today, most of us find that after this Schedule 5 and Schedule 7 coming into place, we find that many of the cases, the applications are filed before the arbitrator asking for the change of mandate, or straight away under 14, applications are filed before the Honorable Court stating that there is a de jure restriction and the arbitrator's mandate has to be changed. This is another aspect which parties directly visit to the court for having their grievance redressed. Apart from that, there is section 27, which is also an intervention of the court, where we ask for the appointment of an expert or the document to be called for, or expert evidence or a third party evidence. There's also section 37, against an interim order under section 17, you go on an appeal. So that again, we find this provision. That apart, most of the other intervention are only under 34. Like for instance, the orders passed under 12(3), 16, all these things go only after 34, along with 34.
With this, I can stop the question. My questions for a while. I have permitted the participants to unmute themselves. Whomsoever have any doubts with regard to the intervention of court can pose their questions to the speaker.
I think there's a question in the chat
that
box.
I will read. Just
okay.
Whether judicial intervention has an effect expediting the process of arbitration while maintaining the sanctity of the principles of arbitration. Raised by Sai Sudha Kuberar.
Yes, the intention of all judicial intervention by the court is only to expedite and have the smooth functioning of the court. That is the intention of the act, and courts have also been doing that by and large. Of course, there are stray cases that too arise only because of the overburden that the courts have, especially in cases where we need to get an appointment of the arbitrator or change of mandate. Of course, today we need to say that the change of mandate is being dealt with at a very speedy manner. We get judgments, orders appointing the arbitrators, or in the change of mandate, the our newly appointed arbitrators. They're all now at a faster pace than was what it was earlier. Of course, we always expect things to be faster, but this one is getting better. So my opinion is courts have always been in support of the smooth functioning of the arbitration. That is why they are also filling up the blanks wherever the act is not providing. They are trying to fill in the blanks, like the judgment of His Lordship Justice Swaminathan was really a path-breaking judgment where he gives the process. So such judgments are the one which make the arbitration process go on smooth.
That's another question by Mr. Balaji. Section 34(6) mandates that the court to dispose of the petition expeditiously and in any event within a period of 1 year. The word used in the provision is shall. What is the recourse if the petition is not disposed of within the period of 1 year?
I think there is a judgment which said that shall be treated as may, and it has not been mandatory now. It is because the moment it comes to the court, it is very difficult for the courts to complete it within that period. So the mandatory aspect has been reduced. Similar provisions are also available in Consumer Protection Act, and courts have also held there that though it is mandated there, but it will be treated as expeditiously as possible.
I think that's no more question.
Good evening, Ashok. Ashok, I do have.
Yes, I know, sir. You had questions.
No, that was rather not in the topic also, today's topic.
Yes.
In fact, if an award is, that may be intervention of the court also, if the award is challenged. And if the court finds that there is some discrepancy in the award and is setting as the award or remanding back the award to the arbitrator again to conduct afresh. In that case, what will be the arbitrate fees? How to deal with that?
No, actually, there are two parts to this question. One is the fees that has to be paid to the arbitrator. The other one is what will be remanded to the arbitrator. The arbitrator is, when it is totally set aside and de novo proceedings is made, then it is afresh. Generally, what the section actually says is, what permits is, when there are certain elements which are found, which are entitling the party to set aside an award, and that ground, to resolve that ground, the parties, it can be sent to the arbitrator, who will give a finding on that, and thereafter the award will be closed. That is how it is mentioned. I can read section 34(4). Actually, I had all these things for the next session where we are going to deal with 34, but anyway, I will 34(4) I will read. On receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by the party, adjourn the proceedings for a period of time determined by it, in order to give arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as, in the opinion of the arbitral tribunal, will eliminate the grounds for setting aside the arbitral award. So the purpose of of remanding is only to eliminate the ground for setting aside. And one more thing we need to find out is, it is only because that ground was not properly adjudicated. So in my opinion, it is a continuation of the same proceedings alone. So the question of paying additional fee is subject to the party's agreement with the arbitrator. Otherwise, it is the continuation of the same proceedings. If the arbitrator still asks for it and if you find it unreasonable, section 14 is there, seek for a change of mandate. And especially when both the parties join together, at any point of time, the mandate of an arbitrator can be changed.
Okay, thanks, Ashok. The other one, which even before commencing our session, I was trying to ask, we discussed,
Yes.
so let us ask in the, that is, again, it's going out of the topic.
No
In
problem.
case during the proceedings of arbitration, if the arbitrator finds there is some criminality or an offense, IPC, involved, white collar offense, like forging of document or some other, what is the duty of the arbitrator? How you should deal with it? Because you cannot pass any award, punishing him.
Yes, what happens is arbitration, as you rightly said, cannot deal with criminality of any act. So even any criminality is to be considered in arbitration proceedings is void. So this has been dealt with in MN Global and also in the previous judgment also, Ayasami and other judgment. So what the courts have held is when it comes to the criminality of it and the dispute arising out of it and the cause and the resultant will be of a criminal in nature, then it cannot be arbitrated. However, if there is an act of criminality, but on the flip side of it, there is a compensation that has to be arrived at or the damages is there, which is not going to decide on the criminality of the person, then it can be considered. The moment there is a criminal aspect to it and which is blended with the relief, then it cannot. If it can be severed, then it can be arbitrated. Otherwise, it cannot be arbitrated at all. It will come under the aspects which cannot be arbitrated. So disputes which cannot be arbitrated.
Thanks, Ashok. Thanks for highlighting that.
Thank you. Thank you, sir.
Yeah, we have another question from one Mr. Karthi. He has raised a question: is it not unfair to fix arbitration jurisdiction in a loan agreement at a faraway place from the borrower by the bank? Is the main motive of the bank is not to let the respondents, that is borrowers, to attend the hearings?
See, this is predominantly based on the parties' will and pleasure at the time of executing the agreement. And it is also several times brought to me also saying that the parties are far away, so they are not able to participate in the arbitration proceedings. I think we have gone far away from this particular plea. I would suggest everyone not to stop with this plea alone, saying that we are not able to access to the arbitration proceedings. It's not so. Today we are in the era where we can send our communications, go ahead based on the documents alone. So any objection and every objection can be raised and sent to the arbitrator by post also. And it has to be considered by the arbitrator. Today, we are going to the next generation in the arbitration proceedings where we are going to have documentally only arbitration. Section 29B, if you go in depth, fast track arbitration and documentary only arbitration are totally being sponsored or supported by the courts and by the act. So we have gone to that exchange. Now, once if they impose a clause of section 29B, which is not far off, I see it in the near future coming up in every other contract. Are we still going to talk about the place of jurisdiction? All these things I think is of no matter. Today we are all here listening to this discussion from various parts of Chennai. Let's assume that there are people outside of Chennai also, outside of the state or outside the country. Still are we going to talk about jurisdiction? I think we have gone past all these things. This pandemic, one good thing that this pandemic has brought in within us is that we can transact, we can go ahead with beyond jurisdiction. So the only clause of saying that the parties are not accessible to the arbitrator, I don't think so. Still, it is a viable aspect. We need to go ahead with, because courts and Supreme Courts have repeatedly held. Now, morality, I'm not going to talk here. I'm going to talk only on the law aspect. yes, courts have repeatedly held that such a clause is totally valid. In fact, one recent judgment I can tell you, of course, that's an international arbitration, Uber judgment passed in Canada, where they were not, the parties, all the drivers were asked to go to Sweden to conduct their arbitration, whereas they were plying their taxis in Canada. Toronto, the person, driver in Toronto was asked to go to Switzerland for Sweden to conduct this arbitration. That they said, no, it originated here in Canada, so it has to be done here itself. So that is the only circumstances in which I have found that such a judgment has been passed. But today things are different. We can always send the proceedings by way of a post, send it by, even there are many who are now going ahead with the emails also. Many arbitrators accept email communication. I accept email communication. And near future, we are trying to bring in ODR as a concept. So in fact, if the organizers permit, I would also be going on one session totally on ODR alone. So that today ODR is online dispute resolution. So everything is going to be online. Any part of the world, you can still resolve your disputes. So such is the era in which we are. So we need to, I think, get more adapted to all these aspects and overcome the difficulties that we think is there in these aspects. Otherwise, the law is very simple. It says that it is the party's autonomy there, and that shall prevail.
We can have that ODR as the fifth session if you can accommodate us, or you can highlight it to us. The next question is made by Mr. Jagdish. Whether Indian arbitration proceedings are cost effective. He feels that the judicial proceedings are lesser expensive than the arbitration proceedings.
Judiciary proceedings are, yes, to an extent, when you sometimes, especially when you take the Schedule 4 of the Arbitration Conciliation Act, or certain judges, retired judges, especially Supreme Court or High Court judges, they have their own decorum and aspects, so that cannot be compromised. So at that point of time, yes, it becomes slightly expensive. There are certain people who are expensive, but I think it's all up to the parties. If the parties feel no, that this is not viable, then they can always change the mandate of the arbitrator, or they can go to another arbitrator. So they can fix the fee according to their whims, I mean, their comfort rather. So with respect to the overall cost, one has to see the overall cost that a litigant will be incurring. Litigant incurs the cost not only for the advocates, but also for the his travel, his the court fee, everything combined. If you combine, and the number of years he has to wait. When all these things compare, I think still by and large arbitration is most economical and viable also, and very effective.
The next question is by Sai Suderan. Does invoking an arbitration clause by either of the parties preclude exercise of Section 11 jurisdiction by the court?
So, invoking of section arbitration clause is, as I said the other day, it is under Section 21. It is akin to filing a suit. So what happens is, will Section 11 come into play just because a plaint is filed? If yes is the answer, yes is for this. If it does not, then here also it does not. So it depends on which stage it has gone through. Just initiation of arbitration, of course, it starts off the litigation immediately. But that's how it is.
Next question I have it from Mr. Balaji. He says that Schedule 5 and Schedule 7 of the Act provides for similar clauses. Clause number 1 to 19 are almost similar, though the schedules are different, and one deals with justifiable doubts and another deals with ineligibility. He requests you to clarify why such clauses are repeated in both these schedules. Instead of, we can have it as a single schedule.
Okay. I think Balaji has not seen the previous videos. Anyway, I'll explain to Balaji about this. Balaji, now the issue is with Schedule 5 comprises of two parts. One is whatever is mentioned in Schedule 7 is all incorporated in Schedule 5. And the other part is justifiable grounds, which are also incorporated in Schedule 5. Schedule 6, you would see a disclosure that has to be made, which combines both Schedule 7 and Schedule 5. So it will give a disclosure statement has to be given. So for that purpose, what happens is whatever schedules that whatever articles has to be disclosed, an overall picture is given under Schedule 5. So only those clauses which totally make up arbitrator ineligible to perform as an arbitrator is mentioned in Schedule 7. So for the purpose of disclosure, the entirety is mentioned in Schedule 5, and for the purpose of clearly understanding that these are the points which are totally ineligible, which make an arbitrator ineligible, they are given under Schedule 7. As I spoke earlier also, apart because the part of 7, the rest of the clauses mentioned in Schedule 5 are only the guidelines which say that this may amount to a act of bias, and they do not, as it is, mean bias. So there is a small edge, you can say, if you take in a golf language, a person passing an award who comes under certain provisions of Schedule 5 is 2 or 3 handicaps there and closer to the award being called as bias. So that is the stage in which it is. So as it is, Schedule 5 will talk about the entirety. Schedule 7 will talk only about the illegality, and it is all placed together for the purpose of giving a disclosure under Schedule 6. I hope I've cleared Mr. Balaji.
Okay. Then last question is raised by Mr. Om Prakash. In case where the court set aside the award on technicality, can the party initiate fresh arbitration? In which case, how the limitation is saved?
Can you just repeat that question? I got distracted.
See, in case where the court set aside the award on technicality, can the party initiate fresh arbitration proceedings? In which case, how the limitation is saved?
Yes, this has also been answered right away. I'm not able to give you the citation. When the setting aside has been done in de novo and a fresh proceedings is entitled to be commenced, then it will start afresh. And the limitation will be taken as the first date of limitation, and the subsequent proceedings are as a continuation of the earlier. Supreme Court has held it so, where they have specifically stated that it will start immediately, and as a fresh claim it will start.
I had purposefully muted my video. And the next question is by Mr. Karthi. Why people prefer arbitration more than conciliation? Is that because they don't get greater awareness about the conciliation proceedings, or is that they don't want to prefer conciliation proceedings?
No, conciliation and arbitration are predominantly different. I would not say that they are one and the same. They travel only at the end of it together. Otherwise, they are totally different. One portion of it alone is can be said as identical, which is the passing of award. In arbitration, you have the resolution of dispute by way of an adjudication. So a dispute is sought to be resolved by an arbitrator, where he gives his adjudication on the said dispute. Whereas in case of a conciliation, the conciliator talks to the parties and arrives at a mutually agreeable terms by which they want to resolve their dispute. So these conciliated agreement are, conciliated aspects which are agreed upon by the parties are brought on record, and they are found as a conciliated agreement, and that is converted into an award. In an arbitration, the award can be challenged under Section 34 by way of a setting aside petition, whereas a conciliation award cannot be challenged as it is a mutually agreed and accepted provision. So there's a very good aspect of conciliation is wherever there is a chance of the parties trying to settle, it is always better that they go by way of conciliation. And in fact, I feel that conciliation is more and much more effective than the present trend of going into mediation. See, mediation, you get an award, you get a mediated agreement. Today, though we keep telling that in near future, we will be getting all these mediated agreements as the established law or decree in par with decree, that has not yet come. So, whereas the said provision is available in India, we have a process of conciliation, which is none other than the process which now internationally they are trying to bring in the form of mediation, and the recent convention in Singapore also talks about the same thing. Such a provision is already embedded into our Arbitration Conciliation Act, and we already have the system. I do not know for the commerciality or for whatever reason, this has been made more popular in the form of mediation and mediation agreements. Even the present law under mediation agreement, if it is not attached to the court, it is only an agreement which cannot be enforced. It can be executed, but it cannot be enforced. Whereas a conciliation award can be enforced, and it is a final. It arrives at a finality. Excepting for the word domestic word of conciliation, and not a mediation as a hybrid term. Conciliation has all the good effects.
The last couple of questions. Again, from the Sai Sudha Peran. Does the judicial authority have any power at all to refuse relief under Section 8, assuming that the applicant has satisfied all the conditions envisaged therein?
Yes, the judicial authority has to go through about 4 different conditions which has to be noted down. So what the judicial authority has to do is, it has to see whether there is an arbitration agreement between the parties. Then it has to see, are the parties bringing an action in this court against the other party who is a party to the agreement. Then the subject matter of the dispute, is it arbitrable and is it pursuant to the arbitration agreement? And lastly, it has to see whether the said dispute has been raised. I mean, such application has been raised before the filing of the first statement in submission. If it comes within this purview, the court has to refer the parties to arbitration. It cannot say no.
Okay, I think this should end the session. I think you can fairly tell us what should be your next part will be covering about.
Next part that I will be covering about will be 37 and 34. Or if the organizers want me to skip that and go to ODR and then come back to 37 and 34, I can do, but that I will leave it to the organizers here to decide, especially you.
No, you take the call. You can take the call.
I will finish 37 and 34. So that completes the portion part 1 of the Arbitration Conciliation Act by and large, because whatever I wanted to say about conciliation, my good friend had raised a question and I wanted, whatever I wanted to say, I said about that. So I can straight away go to 37 and 34, and thereafter we will go for the ODR.
Right. So this should mark the end of the third part of the series of Art of Arbitration. And we thank Mr. Gajapathy, Ashokapathy for his quite an enthralling session. And thank you, friends.
Thank you. Thank you.